Have you ever wondered what happens when the standard rulebook of law just doesn't fit? I mean, what do you do when the person standing before a judge is either too young to even understand their own actions, or, on the flip side, so incredibly powerful that they essentially represent the state itself? Well, today we're exploring the fascinating world of Malaysia's special courts. It's a legal system specifically designed to tailor justice for exactly these wild extremes.
I want you to literally imagine this for a second. Should a 10-year-old face the exact same judge in the exact same imposing courtroom as a hardened adult? It feels fundamentally wrong, right? And that instinctive gut feeling you have, that is exactly why specialized legal architecture exists. True justice just cannot be blind to the basic realities of human development.
Under the Child Act 2001, anyone under 18 is legally considered a child. But here is the absolutely critical part, drawn straight from Section 82 of the Penal Code. A 10-year-old lacks criminal responsibility altogether. The law draws a very hard, definitive line when it comes to cognitive development. If you're under 10, you literally cannot form the criminal intent required to be guilty of a crime. But what if you are between 10 and 18? Well, you need a system that addresses your actions without completely destroying your future.
Here is our roadmap for today's explainer. First, tailoring the justice system. Second, rehabilitating the youth. Third, judging the rulers. Fourth, military discipline and order. And finally, the special courts formula.
Let's kick things off with Part 1, Tailoring the Justice System.
Now, standard courts are built for standard cases, but society is incredibly complex. To maintain actual fairness, the justice system has to bend and adapt. The absolute fundamental mission of the Court for Children is to protect a child's welfare and secure their rehabilitation instead of just slamming them with severe punishments. This is the core focus I really want us to zero in on today. Replacing the old Juvenile Courts Act of 1947, the modern Child Act completely shifted the legal paradigm. The goal here is absolutely not retribution. It's not about locking a young person away and throwing away the key. It is a deeply, deeply rehabilitative mission designed to help young offenders learn from their mistakes and get back on track.
Moving on to Part 2, Rehabilitating the Youth.
Take a look at the composition of this court, because it's fascinating. You don't just have a single judge sitting up high. 2 magistrates are assisted by 2 state-appointed advisors, and one of those advisors must legally be a woman to ensure welfare is prioritized. Why mandate this? Well, a courtroom is terrifying for a kid. By legally requiring these advisors, the court makes absolutely sure that the emotional, psychological, and developmental interests of that child are being actively weighed in every single decision. They're looking at the whole child, not just the broken law.
Now, this court handles criminal offenses for those under 18 using the Criminal Procedure Code. But there is one massive exception: cases involving the death penalty. If a child commits an offense carrying the death penalty, the Court for Children does not have the jurisdiction to hear it. Also, and this is crucial, if a person turns 18 before their trial wraps up, they actually age out of the specific court's protection. The jurisdiction is strictly bound to that legal definition of childhood.
But for the cases they do hear, Section 14 grants the court a highly flexible rehabilitative toolkit. Instead of a traditional prison, an offender might go to a probation hostel if they're around 10, or maybe a Henry Gurney school if they're 14 or older. Think about it. Sending a kid who made a terrible mistake to a standard prison is just going to turn them into a hardened criminal. So instead, they might be placed under the watchful eye of a social welfare officer or sent to an approved rehabilitation center. The whole structure here is built around education, supervision, and genuinely giving that young person a second chance at life.
Which brings us to Part 3, Judging the Rulers.
So, we just looked at the most vulnerable. What happens when we flip the spectrum to the absolute most powerful people in society? Let's talk about holding royalty accountable. Established under Article 182 of the Federal Constitution, the Special Court for Rulers was created to ensure that even the highest sovereigns are subject to the rule of law when acting in their personal capacity. Historically, rulers enjoyed absolute immunity, but a modern legal system demands that no one is entirely above the law. So this court was a groundbreaking shift, ensuring that if a ruler, or even the king, the Yang di Pertuan Agong, commits a civil or criminal act outside their official duties, there is actually a legal avenue to address it.
But as you might guess, this accountability follows a very strict, structured flow. It kicks off with a mandatory green light from the Attorney General to ensure only genuine cases proceed. Because obviously you can't have frivolous lawsuits harassing the head of state. This first step is a massive filter. The Attorney General evaluates the evidence and has to grant permission before a single piece of paperwork is filed. If it gets approved, the case goes to this highly exclusive court, the only body in the entire country with the authority to hear it.
The stakes here are astronomically high. That's why the Conference of Rulers appoints a 5-member powerhouse panel, chaired by the Chief Justice of the Federal Court. Think about the gravity of that. You are judging a sovereign. A standard magistrate just isn't going to cut it. You need the absolute highest legal minds in the country. We're talking the Chief Judge of Malaya, the Chief Judge of Sabah and Sarawak, and 2 other highly senior judges. It's a legal heavyweight team built specifically for ultimate constitutional fairness.
A great historic example of this in action is the 1996 Farida Begum case, where a foreigner's suit against the Sultan of Pahang was actually dismissed. Why? Because the ruler still enjoyed immunity under the specific circumstances of that time. This case is such a fascinating touchstone. It really highlights the friction of a transitioning legal system. Even though the court existed, the exact application of the law back then meant the ruler retained immunity against that particular civil suit filed by a non-citizen. It just shows how wildly complex constitutional law gets at the very top of the social hierarchy.
Now for Part 4, Military Discipline and Order. Here is where we explore a court where the objective dramatically shifts from constitutional accountability straight into strict national security. Welcome to the court-martial. So remember our intense focus earlier on the youth court being all about rehabilitation and welfare? Well, the court-martial under the Armed Forces Act 1972 is the complete opposite. It is entirely focused on maintaining military discipline. The armed forces operate in life-or-death, high-stakes environments. They simply can't afford the luxury of prioritizing personal rehabilitation over group cohesion and operational efficiency. If an army lacks discipline, the whole nation lacks defense.
This court specifically targets very unique offenses committed by Army, Navy, or Air Force personnel. We're talking about things like aiding the enemy, communicating with the enemy, or misconduct during operations. You are not going to find these crimes in a standard civilian penal code. In the military, an affecting discipline and morale can literally get entire battalions killed. The court-martial has exclusive jurisdiction over these specialized infractions because the personnel judging the crime absolutely must understand the unique, high-pressure context of military service.
The setup is pretty interesting, too. The court has to consist of at least 2 officers from the accused's branch who have served for at least 2 years. But notice this proportionality. The minimum rank of the president actually scales up with the size of the judicial panel. If an offense is severe enough to warrant a larger panel of 5 or more officers, the law dictates the president must be at least a lieutenant colonel. For a smaller panel dealing with a less severe infraction, a major can preside. It's a brilliant way to ensure the gravity of the oversight perfectly matches the gravity of the charge.
And because we're dealing with national security, the punitive powers here are incredibly severe. We're talking punishments reaching up to a 14-year prison term or even the death penalty. Unlike those youth courts we discussed, the primary mechanism here is absolute deterrence and punishment. Aside from prison, you've got dismissal from service or forfeiture of seniority and rank, which basically strips away a soldier's livelihood and honor. It sends a completely uncompromising message across the ranks. Breaches in military integrity simply will not be tolerated.
And finally, Part 5, the Special Courts Formula.
Okay, now that we've seen these incredibly diverse courts in action, I'm going to give you a quick cheat sheet to decode literally any special court you ever encounter. Just memorize this 5-step sequence as your ultimate blueprint. 1. Introduction. What law created it? 2. Composition. Who actually sits on the bench? 3. Jurisdiction. What exact cases are they allowed to hear? 4. Special powers. What unique punishments or orders can they hand down? And 5. Conclusion. Why does society even need this court to exist? If you can answer these 5 points, you can master any specialized legal system in the world.
So, whether it is rehabilitating a child, holding a powerful ruler accountable, or disciplining a soldier, these courts absolutely prove that true justice adapts to the unique circumstances of the individual. Think about it. A rigid legal system that treats a 14-year-old truant, a reigning king, and a treasonous soldier all exactly the same? That is a broken system. Real justice requires nuance. It requires a society to build customized legal machinery that addresses both the context of the crime and the status of the individual.
Which leaves us with this final thought. If justice must adapt to the extremes of youth, power, and war, how else might our legal systems need to evolve for the future? As technology advances and our society grows even more complex, what new special courts will we need to build next? Thank you for exploring the architecture of justice with me today. Keep asking the tough questions, and I will catch you in the next explainer.